Most New Mexicans who are in a car accident since 2020 have no idea their own insurance company may still owe them money. Now, I know that's going to sound like clickbait, but I promise you it isn't here. You already paid for something called uninsured or underinsured motorist coverage. It's called UMUIM, but here's the problem. Insurance companies sold people policies that really vanish when they need them most, and you paid for that protection. And so when the time came, it was worth zero. And so what happened then in 2021, the New Mexico Supreme Court said that insurance was fake. And in 2024, they confirmed that that applies retroactively, meaning that if you were in an accident from 2020 to today, you may still have a valid claim, even if you already collected from the other driver. Here's what usually happens. You get in a wreck. The other driver has minimum policy limits of $25,000. You collect their $25,000 with your damages, and your own insurance company says, sorry, your UMUIM coverage is offset, so we're zero. You walk away thinking you're done, and that's not the whole story. So the problem, that's what the court called illusory coverage. You paid for coverage. UMUIM in a situation when you needed it, but in that exact situation you needed it and it disappeared, right? It's supposed to protect you from under and underinsured motorist coverages. Crutcher forced insurance companies to admit what they've been doing. They had to disclose that you were paying for coverage that might not actually be there in the situation when you actually needed it. Now, if they made that disclosure after 21, fine. But before that, they were taking your money and wiping out your UMUIM. That disclosure is called a Crutcher disclosure. You usually use the name of the case Crutcher and is in your policy. In 2021, lawyers challenged that rule in Crutcher versus Liberty Mutual. And the court said, that's fake insurance. You can't do that. Insurance companies tried to limit it going forward, say just do that going forward. But in 2024, in Smith v. Farmers, the court said that goes retroactively, meaning it goes back in time to even before Crutcher and accidents before 2021, as long as your damages were above the other driver's limits. So you're probably asking yourself, do I qualify? Here's how to know if you qualify. Your accident happened in New Mexico after 2020. You usually have about 6 years to bring a case of UMUIM, and so that's why generally the best ruling is 2020. There are other exceptions. The other driver had $25,000 or minimum limits coverage. You collected their full coverage. You had UMUIM coverage on your own policy. You have to have some kind of insurance. If you had nothing, there's nothing this can do for you. There was no Crutcher disclosure in the policy. That's really key here. And you never filed a UMUIM claim. That one's not absolute. There's some wiggle room. If you tried to file with your insurance, it actually could get you more time. Most importantly though, your damages have to be worth more than $25,000. That last part is really key. If your medical bills, lost wages, pain and suffering, or other damages that might have come from a car accident were greater than $25,000, then your own UMUIM coverage should have stepped in. Now, if your damages stopped at $25,000, then there's nothing left UMUIM to insure you for. If this checklist looks like your case or what you experienced, you may have a Crutcher claim. And that's money your insurance company is not telling you about. So what's at stake? Here's what that looks like in practice. If your damages were exactly $25,000, the at-fault driver's policy covered those damages, and there's nothing left, that's it. There's not a claim for you. But if your damages were $35,000, $40,000, $50,000 or more, your UMUIM coverage should have stepped in to make up that difference. Without Crutcher, you walked away with just $25,000. Now with Crutcher, and as long as no disclosure was made, you may recover the full value of your damages, up to your policy limits in addition to what you got. This even applies when the other driver had more than $25,000 in coverage, say $100,000, and you had matching coverage. Or even if you had an offset from their coverage. They had lower coverage and you had a higher amount, that can still apply there. These cases get more technical though, so let's talk about an example of what this looks like. One New Mexico driver had a 2020 accident, their medical bills and other damages were $50,000. The at-fault driver had $25,000 in coverage. At first, they thought that $25K was all they would get, but they had that UMUIM coverage. With Crutcher, they recovered another $25,000 from their own insurer, plus in some cases attorney's fees. The key was that the damages were higher than the at-fault driver's limits, right? That's how that claim even happens. If your accident was in New Mexico since 2020 and you recovered from their insurance and no Crutcher disclosure was made, call us for a free consultation. You don't pay unless you win. Thousands of New Mexicans are sitting on money they don't know they have. The only question is, before this all expires and time runs out, are you going to let the insurance company keep it, or are you going to claim what's yours? Don't let the insurance's bad decisions prejudice you. Call us at Hudson Injury Law.